town around lunchtime. So, yeah, I was just roaming the fields. Getting a feel for the area. I've never been to this campus before. So. Okay, yeah, it's mine as well. Yeah, been to South by in Austin, but never to RightsCon. But you're from the US?
Yeah.
Oh, I couldn't distinguish. But I was wondering if it's really US. Yeah, that's what I was wondering. Yeah. Okay.
So I'm speaking. I've been asked to speak more around some of our work around
Really great.
access to
Or there's
barriers to
just been more
access
than
to
one.
justice and judicial remedies. So that's my spin on this panel. So we're a coalition of non-profits in the business and human rights space. We're based in DC. Our board's kind of made up of human rights law, diversity, women's rights, and others. And then I lead our access to
Oh, nice.
but I've only been with ICAR since November. I moved from Sydney
Oh,
to DC.
so it's from Sydney. Very nice. I got a couple of friends down there. Yeah.
Have you been before?
No, I've never been there, but I'm just following their Facebook streams. So I always see those spectacular beach wilderness around Sydney. Yeah, maybe Nick, right? Nick is actually kind of tutoring emerging NGOs. That's what he does, I guess. I forgot the NGO that he's with. Nick Wrightis. I think he's relatively well known in the Australian NGO sphere.
Yes, I know the name.
Yeah. He's really nice. Yeah, I met him through friends. We didn't work together on NGO-related matters. We worked together in the tech field.
Okay.
But I really like him. He's a very nice guy. And I think he does an amazing job. Get up, yeah.
Oh, do you know Barbara from the NGO community in Australia? I'm like, yeah, because it's actually a really small community.
All right, we'll get started.
Sorry.
No problem. Thank you for all of those things for the last panel of the day. I know it's been a quite long day. Welcome to this last session called Bring Back the Lawyers. I'm really happy to have all the great panelists we have today to discuss litigation as an advocacy tool for policy changes. If you've been at RightsCon here 2 years ago, we had a session called Fire the Lawyers, which explained the title of this panel, because 2 years ago we were in a situation where we were thinking, well, we don't need that much lawyer, maybe with a lot of engineer we can fix all of the problem of the internet, and we should be fine. We've unfortunately seen over the last year that we still need litigation, and it's actually a growing movement, and we need to bring back the lawyer to the room, which is why we have the panel here today, and we'll be discussing experiences in litigation and other types of remedies in order to bring policy changes that we've not been able to get through advocacy. So I'll let the panelists explain already their experience, and we'll start first with Nani Jansen from MLDI to give us their feedback.
So my name is Nani Jansen. I'm the legal director from the Media Legal Defense Initiative, short MLDI. We are an organization that works worldwide to help journalists, bloggers, and independent media defend their rights. The reason why I'm on the panel, I suppose, is because litigation is our bread and butter. We came into existence to make sure that journalists, bloggers, when they got sued for doing their work, wouldn't be encumbered too much by these legal proceedings. We would take away that burden as much as we can, so they are actually able to continue doing their work. Our support consists of both providing very concrete ad hoc support for individual cases anywhere in the world, helping someone find a good lawyer to defend their case, assist in paying legal fees, and then also working together with the local lawyer to make sure that they have everything they need to put up a proper defense. In addition to that, we also engage in strategic litigation, so that's litigation at mostly the international level, in which not only the outcome in a concrete case is important, but also a more overarching goal, one that could, for example, lead to a change in legislation in a country and would basically improve the situation for not only the individual that is engaged in the particular proceedings, but also others.
Sorry, no problem. Thank you. Well, we'll be moving along to Max Schrems. For those of you who don't know him, though, if you've been reading the press recently, you might have heard of him, or at least a case carrying his name in the EU. So Max is a PhD law student from Austria, and in his free time, he challenged data transfer agreement successfully in front of the European Court of Justice, and he's also challenging Facebook on the basis of a class action in Austria, and we'll hear more about your experience on that.
Is that working? Number 5? Okay, it's not. Let's just use this one. Okay. Thanks for the invitation. First of all, basically we had 3 cases. A couple of them were, the first round was in Ireland against Facebook, where we're looking at what Facebook is doing with the data, like internally on a consumer side. That was not too successful because the Irish Data Protection Commissioner was not too interested in intervening with the investment that happens in Ireland. And the second round we did was a challenge that went up to the European Court of Justice on the Safe Harbor Agreement. Under European law, you're not allowed to send data to another country unless there's proper data protection, because it wouldn't make sense to have data protection in Europe, send it somewhere else, and then it's not protected anymore. And there's an agreement with the US, which was called Safe Harbor, under which pretty much all the big companies are sending data from the European Union to the US. And we had the situation after the Snowden disclosures that Europe was outraged about all the mass surveillance, partly doing the same thing itself, but that's another story. And it was interesting to find a way to actually get some movement, because we had angry letters from Merkel and we had like all this kind of political fuss, but we knew that this is not going to lead to anything. We had like demonstrations, policy work, and that whole deal. And the interesting thing was in mass surveillance cases, we found that you have a government that actually accesses the data, but you also have a private company that has to to hand over all this information. Obviously, we don't have jurisdiction over the US government, but we do have jurisdiction over Facebook, because Facebook's main headquarters internationally was in Ireland. So anybody outside of the US and Canada had a contract with the guys in Ireland. And because they were subject to European Union jurisdiction, we were able to say you're not allowed to send data to the US anymore if this is used for mass surveillance. And we won on that, striking down the Safe Harbor Agreement. And that was a very interesting case, because we're really looking at a specific way to target something which we couldn't have otherwise targeted. Foreign government is something you can typically not target, but their interest in having commerce with the European Union is something where you can actually get some, have something you can actually hit on, and where you also have jurisdiction. The third thing we're doing right now is a class action in Austria. So we had, that's really on consumer privacy more, against Facebook as well. And in this case, we're asking for a token amount, €500 per person, for all the things that Facebook does with your data, starting from having absurd privacy policies to whatever. And in this case, we needed people to sign up to the class action under Austrian law. So we had a little web page where you could sign up your claim, and you had to log in with your Facebook thing. So there was a login with Facebook thing, and upload your passport and fill out forms and whatever. And it took people on average 15 minutes to fill that out. And I thought we need to have a couple of thousand people over the time. After 6 days, we had 25,000 people that signed up to it. So we actually had to shut it down because there were too many people signing up to the thing. And that was very interesting to see how many people are actually interested in doing something about it. The whole case was also financed by procedure financing companies, so they get a 20% share if we win the case, but they also cover all the costs if we lose the case. So that was very interesting as well, how to finance stuff like that. I think that's a couple of things to put in at the beginning.
Thank you, Max. We're moving now to our third speaker, which is Apar Gupta, who we're moving from Austria to India to here.
Also has social and cultural values which are at certain points conservative and differential towards government narratives and defenses towards restrictions on online freedoms. For instance, there are greater arguments to place greater restrictions on online content, given that it spreads faster, while are pending for a long period of time. The process of prosecution itself or participating in a civil trial is equal to the punishment in which you're paying a lawyer or you're compelled to attend court. Given this, it made sense to challenge the provision by itself. Thankfully, the government, the provision was being incredibly abused and used in instances which could help us paint a narrative in which we could argue that there is not an abuse in the exercise of the provision, but but there is an abuse inherent in the provision itself. And this happened when two young girls were arrested. One was Hindu, the other was Muslim. And this is important because it showed a narrative where people from across religious groups, who are young girls, who are well-educated, who don't come from an urban center, but come from a smaller city. And it gave us a springboard towards challenging the provision itself. The Supreme Court struck down the provision, relying on constitutional doctrines, which are well contained under Indian law, have been developed through precedent, through the process of stare decisis over decades. But the court does not apply it always. There is a context which it requires. There's a certain level of urgency which needs to be shown. And I think this process is what is right now missing from strategic litigations in India, where we can map, for instance, what is the trend in the Supreme Court in striking down provisions or even hearing appeals with respect to certain civil rights preceding 3 weeks prior to the filing. So we can probably map whether we should file right now, we should hold off. It's more episodic, it's more ad hoc. And I think that's one learning which has come through from this litigation. Another thing, and I think it's been mentioned on certain panels, is that when there's a confluence of interests, civil society, industry, as well as a certain segment of government being receptive to arguments, change occurs. And I think that also exists in litigation. Once there's a confluence of interests, it's not a pure civil society argument per se, which is incredibly being put under stress in India, especially for being activist or for being opposed to conceptions of development. When it's also an industry interest which matches with civil society, which matches with larger development goals, it works. So I'll end it at this right now. Thank you.
Thank you, Apar. I think we'll be moving to Ulf Bomeyer for the next intervention, which is interesting for that panel because we're looking at lawyer so far that has been experienced, and Ulf is an experienced judge in Germany, and he's now starting with GFF a new project on litigation, and that would be a new way to discuss why you actually decided to enter into that movement of litigation and why maybe the elements that you had to consider in creating that project.
Yeah, thanks, Estelle, for inviting me to participate in this panel, because actually I don't see my role that much as somebody who shares a lot of experiences, because our journey has just started. I see myself much more as a learner, and I'm really happy to get to know what you are doing. Just to give you a little bit of insight, of course, there has been court cases in Europe and also in Germany when it comes to digital freedoms, but there has not been something that you could honestly call strategic litigation, because there simply was no body, no NGO, no organization that would undertake such litigation. And when I studied in the US, I got to know the amazing work that organizations like the ACLU or the EFF do. And so I thought, well, we need to have something as strategic, as planned, and also as effective back home in Europe, and in particular in Germany, where I'm from. And so I started talking to the NGOs that we have in the realms, NGOs like Amnesty International, but also smaller German ones, like the CCC might be well known to somebody, like the hackers organization Chaos Computer Club. And everybody said, well, it's an amazing idea, we do need this, but we don't have the resources, but we would like to participate in the effort if you go ahead with it. And so about a year ago, well, not even, in September 2015, it feels like like a year ago, but it's only half a year, we founded a new umbrella organization which is going to undertake exactly that. So we have set up an association, and we have gathered the first funding to bring a couple of cases in the realm of digital civil rights. Because we haven't filed them, I am not really at liberty to share details of the cases, but what I can say is that at least two of them are in the realm of digital civil rights as infringed by government agencies, something that is closely interlinked with the NSA scandal. And this is also a clue topic, I guess, to talk about when it comes to why we actually need strategic litigation, because I don't know exactly how it happens in the US. I have the impression that there is at least some change brought about by Congress as a reaction to the NSA surveillance scandal, but back home in Germany, nothing of that kind is happening. So Parliament is basically ignoring the civil liberty implications that the surveillance agencies have, and German agencies are linked to this, are involved in it, but nobody's doing anything about it. And so the only means that we might have to bring about change here is legal means. We might have to remind government that there is something like privacy, that there are civil rights, constitutional rights involved here, and but it appears that only court cases might be a means to remind government of these rights and to bring about change, at least in the long run. So this is what we are trying to do as a new organization that is, of course, still learning, still being constructed, and it's a very exciting journey, and I'd like to share the experience of the others. Thanks.
Thank you, Ulf. To conclude our round of introduction, we'll hear from Sarah McGraw from ICAR, which will present the perspective from different remedies that are possible in alternative to litigation, and also on the issue of access to courts. As Sarah is our last speaker of the round of introduction, this means that soon it will be your turn to ask the question and everything you want to know. If you're curious about litigation, if you're thinking about bringing cases, if you have a question about the cases we've heard, of the journey that all our speakers are taking. So it will soon be your turn. Now, Sarah.
Thank you. Thank you very much for the invitation to be here and participate in this really interesting session. I provide a little bit of a different perspective. I'm not a litigator. My organization isn't involved in litigation. My organization is the International Corporate Accountability Roundtable. For those that don't know, we're a coalition of approximately 40 human rights, labour, environmental and development organisations that work to create, strengthen and defend policy and legal frameworks to ensure that businesses respect human rights in their global operations. So as I said, ICAR, which is our acronym, isn't involved in litigation, but a number of our members are. But what we do at ICAR is look at how we can reduce some of the barriers to effective remedy, whether it's through judicial or non-judicial mechanisms. So I've been invited here to speak to some of our work we've done on access to judicial remedies. In 2013, ICAR collaborated with two other coalitions to launch a project that examined access to judicial remedies for human rights violations by transnational businesses. So this research involved a combination of desk-based research in addition to consultations with NGOs, retired judges, governments, and also public interest lawyers and corporate lawyers. So the final report, which is available on our website, identifies and analyzes the most significant barriers to effective judicial remedy in the US, Canada, and across Europe. And the reason these jurisdictions were examined is because this is where the majority of transnational corporations are domiciled. So I'll take a few minutes to go through some of the findings. There were 30 plus recommendations in our report, so I'll just stick to 4 key findings that we found were common across all jurisdictions, and because I think they have implications for a lot of the work that my co-panelists will speak to later. So our major finding of this report was that 2 years after the unanimous endorsement of the UN Guiding Principles on Business and Human Rights, states are failing in their obligation to provide access to effective judicial remedies for victims of business-related human rights violations that occur outside of the government's territory. So as I said, there were 30 plus recommendations, but I'll just focus on 4 for the purposes of this discussion. Our first recommendation was that states must ensure that controlling entities within business enterprises have a legal duty with regard to all parts of the business enterprises for human rights impacts. So this means that parent companies have a legal duty for human rights violations committed by its subsidiaries. While there are multiple obstacles to effective judicial remedy in the transnational context, the complex corporate structure within the modern that characterize modern business lies at the heart of this challenge. So without legislation clarifying standards for parent company liability, the twin concepts of separate legal personality and also limited liability make it very difficult for victims to assert that the parent company bears responsibility for the human rights violations of its subsidiary. So our report therefore recommends that states clearly affirm the legal duty of parent companies to exercise due diligence, human rights due diligence, as outlined in the United Nations Guiding Principles on Business and Human Rights, by ensuring that the subsidiary does not engage in human rights violations, whether indirectly or directly. The second recommendation that we found was common across all jurisdictions was the issue of extraterritoriality. States must enable victims of business-related human rights violations to bring a case in the home state of the business. For those that are familiar with the context of the US, you'll be very familiar with the Kiobel case, which has which articulated a presumption against extraterritorial jurisdiction, making it much more difficult for human rights victims to bring a case under the Alien Tort Statute here in the US for abuses that occurred outside of the US. So the third recommendation that I'll touch upon is that states must enact legislation to limit or remove financial barriers that prevent victims from bringing a case. Again, this was a major barrier that was seen across all of jurisdictions. And I'm sure my co-panelists will be very familiar with the fact that transnational human rights litigation can be extremely expensive and costly. And this situation is further exacerbated by the inequalities between parties. Commonly, plaintiffs often belong to marginalised groups and defendants come with a team of well-resourced lawyers. But this disparity would be significantly improved by reforms to collective redress system and also to incorporating costs of proceedings incurred by plaintiffs into the ultimate finding of liability. So the last recommendation, so I'm wrapping up now. The last recommendation I'll just briefly touch upon, and it's not directly relevant to this conversation, but I wanted to raise it for completeness of our research, was that we recommended that states must develop and enhance criminal laws to hold businesses accountable for their involvement in human rights violations that take place extraterritorially and give rise to a crime. So to conclude, our work demonstrated that access to judicial remedy is too easily denied on the basis of procedural and substantive and practical grounds, limiting our ability to bring back the lawyers and also inhibiting the role of litigation in providing effective remedy to victims of business-related human rights violations. Thank you.
Thank you, Sarah. I think we now have a good stage to start the discussion. Please raise your hand if you want to ask a question. I might be the first one to ask actually on this issue of access to court. Basically, I want to ask the panelists, and I know the answer might vary depending on the jurisdiction, which is also interesting for the transnational cases. If you were to consider litigation today, either as an individual or as an organization, if you had top 3 recommendation of things to do or maybe things not to do from your experience or from what you think, what would you recommend if somebody comes to you saying, I want to bring a case similar to yours, I want to participate, I want to make that change? Anyone want to start?
I'm gonna try. Now we got 3 microphones. I think what's interesting, I get a lot of emails like, this thing worked at the European Court of Justice. I have a case here. Don't you want to do this as well? The biggest problem is to separate from what you want politically and what you can possibly get legally. Typically, this oftentimes does not go together. And there are a lot of things we want politically that we're not going to get through court cases. And I think that's the most important thing is, do I actually have a case? Is it stable? Is it something I just want to raise with a court? Or is it something I actually have a possibility to win? And I think that's the kind of the first big thing that I get a lot in practice. If you have such a case that could work, it's a big issue of where do you file, especially if it's something that's not a national law, something where you have an opportunity, especially in the private sector, as we did it, or you kind of, what we did is we kind of went through the private sector to actually hit a government. So it was like playing around, like basically we're targeting Facebook, and if Facebook has a problem to export data, or the whole industry has a problem to export data to the US has a problem overall without even being in court with the US. So it's stuff like that where you can find different ways of getting things that you couldn't get directly, but you could get around the corner. And by using that, you can also choose jurisdictions that are more favorable from a money perspective, from costs, especially in Europe. The problem is that you got to pay the other side's costs if you lose a case. There's stuff like that. That really depends on a lot of the jurisdictions also. So if you have connections to different jurisdictions, it's interesting to talk to different lawyers what the opportunities are. So for example, we filed in Ireland where a procedure financing deal like we did it in Austria is not possible. You don't have another person that can insure you basically against the cost. In Austria, that was possible. We pay 20% of the winning fees. However, we get all the costs back in our class action. You can look if you can, for example, make a class action in different jurisdictions. That's a big issue. So especially if you have minorities or groups that cannot afford something, class actions may be a wonderful tool in certain ways. So I think that's different things that you got to look at and that could be relevant. The biggest problem I see is just really having solid cases, because the worst thing that can possibly happen is losing a case and backfiring at your cause, which is something that is very interesting, I think, as well.
Sorry, just want to latch on to that right away. I think, as you rightfully pointed out, it very much depends on which jurisdiction you're looking at. And then there's an enormous difference between national jurisdictions, etc. I think the overarching question in the beginning is, what do you want to achieve? And then you can determine whether or not litigation actually is a useful tool in your toolbox, because it will be one tool in your toolbox if you want to indeed get the political result that you want. That has to be married to a good strategy as regards advocacy, a plan already as to where you think that you can get the best results as regards implementation. And then you can basically go down a whole checklist of what are my risks, etc. And there also kind of factors in the question like, sure, setting a bad precedent is nothing any lawyer would ever want. However, I also know organizations that do advocacy who say like, listen, just filing a case, even if we know that we can't win, the situation is already bad, it's not going to get any worse. Raising awareness for the case by means of this litigation and thereby perhaps even underlining how bad the current situation is actually something we can use to our advantage. So this is something you have to think about very carefully. And again, that's on a case-by-case basis, I think, whether or not litigation is something you want to go for.
Thank you. I don't know if anyone wants to react.
One thing in addition to this, and I think as a general case strategy, it works well, especially in law, given the structure of the profession is incredibly towards the appearance of formality, tradition, is to hire the right lawyers. These lawyers should be viewed in the sense that they are not only lawyers who, especially for India, who only do public interest work or civil rights work, but are successful litigators who argue the largest commercial claims. And this works well. It shows a legitimacy to the underlying claim as well. And secondly, it also decreases a level of skepticism in the mind of the court that there is, the court is being moved quite visibly to affect a change which may otherwise be required legislatively. So it decreases the amount of suspicion with which the claim is viewed. So structuring the entire strategy as close to a commercial litigation is sometimes beneficial as well. And the second thing, which I already touched upon, was that once one claim goes from a party which may be, for instance, a non-profit or a civil rights group, if you have different interest groups which latch on to that, it's successful in firstly preventing attacks which are ad hominem, and secondly building a larger credibility to the relief which is requested itself. So if you can show businesses interested in it, women's rights is interested. For instance, let's look at a petition in the Supreme Court which is asking for pornography to be made illegal when it is viewed. Right now in India, pornography is illegal if it's distributed, sold, but not when it's viewed privately. So through a litigation, a person is asking the court to expand the criminal penalty. Here there is a opportunity for, and the basis of the claim is that viewing pornography gives rise to violence against women. So there's an opportunity here for a research-based organization, and there is research which exists to show that there's no causal link. There may be a link, but not a causal link between pornography and violence against women. A women's rights organization can come in here and argue that women should have autonomy to consume pornography as well. It's not as if only men consume it. They may consume it overwhelmingly, but it's not as if women should be denied a form of sexual autonomy. And doing it will be a very powerful argument. The third can be a pure civil rights objection on elements of free speech. If you match all three together, it's very powerful. But if only one goes, it can be discredited.
No, sure.
Just on the issue of choosing the right lawyer, just the strategy, that's a very clear one that sounds like a solid one for the Indian context, right? I just wanted to just flag that, again, that's an issue that very much depends on jurisdiction, forum, etc. And particularly for those organizations that don't have in-house counsel that can lead the litigation themselves, it's something you have to be very, very careful about. You don't want to have someone who will hijack the case as a platform for their own star status, if I may call it that. Being a lawyer myself, most lawyers have huge egos, and there are a lot of lawyers out there who do great work, but also kind of take so much pride in their pro bono work that it's kind of a platform for, another agenda perhaps than that of your organization or your overall goal. And you have to be very clear as to what you want to achieve again with the litigation, because there will be very many decisions along the road that will determine the course of the case, and you want to make sure that you have a good I think Yasser wants to say something.
Yes, I think we have a question here. Thank you, Sarah.
Hi, my name is Yasir Latif Hamdani. I'm a lawyer in Pakistan. I've done some public interest litigation. My question to you especially, because your jurisdiction is the closest to Pakistani jurisdiction. You said the strategy is to get the lawyer who would be sort of most commercially the biggest litigator who's litigated those cases. What about funding? I mean, obviously, what you're going to have is that this litigator is going to cost a lot of money. How do you go about how do you strategize about funding? I mean, that's just something I've been very curious about. So.
Several of these lawyers, if they are convinced as to the overwhelming merit in the case, and it's a small community of lawyers who practice in the Supreme Court, they devote their time pro bono. So, but you need to create a team, you need to do the work, assist them in all ways possible, ensure that they study the case also, prepare it well, and eventually they'll give their time for free. They'll appear for free. It's not an issue. The best commercial lawyers do that in India.
Max reacting, and then we have another question here.
Can I possibly add to that? What we did, for example, is crowdfunding. Like the case that went up to the European Court of Justice was a crowdfunding thing. It was interesting because we did our own system, like a friend of mine programmed it actually, where people would get the money back if we win the case. So they could either say we donated to a similar cause, or you get it back if the case is won, because obviously it's just a fund that you need if you lose a case. And that was interesting because I think within 2 weeks or something, we got 20,000 euros in. And I even took down all the links after a while because there was too much money coming in. And we ended up having 70,000 euros in our account as a thing. So that's oftentimes, if it's really public interest, the average donation was 30 euros, so not a lot, but you still got a decent amount. The pro bono thing is really a national thing. Like in Austria, you have lawyers that do pro bono. In Ireland, it was impossible to get anybody doing pro bono. However, they did, for example, no win, no fee. So it really depends on the situation. But especially if you have a good cause that is of a public interest, you oftentimes have the media reporting about it. If you have that was like if you have a crowdfunding or something like that thing, it's interesting as well because it shows the support of the public, and it also makes you independent from donators or foundations and all that kind of stuff. So that's something that worked for us quite well.
Thank you. I think we had the first question here, and then here and here. Okay. Maybe we can take the 3 questions and then.
Yes. Good evening. My name is Sarkis Darbinyan. I'm a attorney at law and a senior lawyer of NGO based in Moscow. So we are protecting the digital rights in Russia, and I have my own legal practice, but I am also a lawyer in this not existing NGO, because we cannot have an office right now in Moscow. We cannot be a registered organization because we face a lot of problems with that. And we are on very low budget for fighting for digital rights and start the litigations for public interest. And what are you, I want to hear what you have some success stories of crowdfunding for litigation for protecting the digital rights, and do you have any support from the tech companies, for example, local companies, local businesses that are interested in protecting human rights? Thank you.
Hi, my name is Fanny. I work for the Electronic Privacy Information Center, but my other hat is the Hungarian Civil Liberties Union. and we are grateful for the MLDI to fund our freedom of information and freedom of speech litigation. And actually my question is about feasibility and success that you partly discussed from a donor perspective when it's not a democratic context, because strategic litigation.
What is, in that case, because my concern has to do with the US law and doing possible litigation in the US. I'm an activist besides, I'm not a lawyer. So what, in that case, what is the general approach? What's the best way to find good pro bono lawyers, representative? By pro bono, I don't mean that eventually they will never be, they could eventually be paid, but I mean, for activists, for human rights activists or organizations, small NGOs, very often they just don't have money to start with. So what's the general approach to find the good pro bono lawyers?
Let me first get back to Fanny's question about the notion of success. I find that a very interesting question, because we are facing the issue at this point that in Europe, but in particular, I think in Germany, there is no culture of strategic litigation. And so people have a very limited idea of what success means. And we are very often confronted with the idea that success is only if you win a case outright. So if the court says exactly what you wanted it to say. But I think for successful strategic litigation, this is the ideal concept, of course, if you win outright, but there are smaller wins, and they can also be very interesting and very important stepping stones. And I think this is roughly what Nini pointed to earlier on. For example, you can lose a case only based on particulars of the facts in that case, but the legal holding in the case can still be very favorable to human rights, for example. So the court might say something is a basic right, but it just doesn't apply in this case. And this can be a very interesting success, because then you know which would be a better case in terms of facts that you might bring as a next case to win it outright. And even if you lose a case completely on a legal matter, if the law isn't made worse, then at least you can still claim this success in the sense that the court makes it completely crystal clear that there is a problem here, and then you can use that as a case that you can scandalize, and you can try to base an advocacy campaign on this case, and either the court or the courts will find that it's illegal what's going on, or at least we can say, well, this is supposedly legal, but citizens, do you really want this to happen in your name? And then we can try to put pressure on Parliament to bring about change on a political level. So I guess litigation and policy and advocacy work always go together. We just have the specific strategic situation back home that there are already a couple of NGOs in place that do policy and advocacy work, and so we can partner with them. What we basically add to their toolbox is the strategic litigation tool, but we don't want to duplicate all the efforts and structures that are already in place. We're just adding the specific tool, which is bringing court cases.
Thank you. Those are all really interesting considerations. If you look at strategic litigation, of course, the question is, what is strategic litigation? And it's really interesting to see that this is taking hold in Europe more and more. I'm on the project board of the Public Interest Litigation Project in the Netherlands, who are also exploring strategic litigation in the Dutch context at the moment. I just wanted to kind of take a slightly step back and zoom out from just the strategic litigation bit in answer to your question, because I'm not quite sure if we're only limited to that on the panel, but I think you can also look at litigation as such as a tool in your human rights toolbox, right? Particularly in countries where you cannot count on wonderfully impartial courts and good judgments, etc. I do think that there's a really good argument to be made that fighting these legal battles to begin with is of importance, and is of fundamental importance in kind of at least pushing back the tide as much as you can. Basically, not fighting certain issues in court means giving complete free leeway to the powers that be to do whatever they want. And that's an argument that I've upheld for a number of countries that we've worked in, where we basically know that we will never be able to actually win a case in the national courts. And you're lucky then that you're in a Council of Europe member states and you can go to the European court with the right cases and get justice there and hopefully set good precedents, and that might scare the authorities a little bit. But yeah, I do think that litigation as such can also just be a tool, even if you lose. So.
Yep. Sarah?
Thank you. I just wanted to kind of pick up on this idea of success and disappointing decisions. I think, you know, in the US, in the business and human rights context, the Kiobel decision was really devastating for a lot of lawyers that had been using the alien tort statute as a tool. And I guess following that decision, and this picks up on the idea of then collaborating with advocates and policy organisations, which mine is, my organisation then partnered with Earth Rights International, which had conducted a lot of this litigation under the Alien Tort Statute, and tried to find a silver lining in the Kiobel decision and, you know, what could be next steps for strategic litigation. And we thought, okay, well, the federal level is closed. What options are there at the state level? And since then, we've actually introduced legislation here in California to extend the statute of limitations for serious human rights torts from 2 to 10 years, and we're hoping to do the same across other states in the US to open the doors for then strategic litigation to take place at the state level, since a doors has been shut for the moment at the federal level.
One thing was on like the good pro bono lawyers. The hardest time I had was not to necessarily find people that want to do pro bono work, but to get people that actually know what they're doing. Like the good is the bigger part oftentimes. And it's incredibly frustrating if you have people that are not really knowing what they're doing. So my experience oftentimes was that it's easy to get people that want to help you, but it's not necessarily the people that really know what they're doing there. They get, especially in the political sphere, they get very enthusiastic about.
Yeah. Your best success story for crowdfunding for the litigation for defending the digital rights.
Yeah, basically, I mean, in our case, it was obvious because it was an obvious cause that a lot of people shared. And I already got emails beforehand saying, if you need money, let me know, blah, blah. And that was because it was a very public case. You also could have kind of created a movement in a way of, we're now taking on this problem, we're going to go to court and fight for this shit. And that was like this thing where you actually got a lot of positive feedback. And because the issue was clear to a lot of people, it's something that a lot of people bugged. And you could kind of show a solution, show not just, you know, we have a lot of advocacy debates where we all sit on a panel and complain how bad the world is, and then we go home and drink a beer. And in this case, we could kind of show this is, you know, this is what we're going to file, this is what we're going to do, and we need X amount to be able to do it. And that kind of generated a positive kind of exit scenario of the whole debate. I think that was possibly what helped. In my case, it was interesting as well because you had this like little student going against a big company, which kind of had this David versus Goliath myth to it, which interestingly worked incredibly good in Europe, but was a reason why, for example, in the US, it wasn't reported because they didn't take it serious. They're like, there's no way a student can win against, you know, Facebook and the government and stuff. However, in Europe, this kind of generated a myth, you know, you got to help that guy thing. So in the end, it's like OPR, you got to tell a story. In my case, the story was the story. We didn't have to create anything around it, but that worked quite well. And you don't need that much. Like if you have, you know, we had 2,000 people donating $30, which gives you 60,000 in the end, and that was what we needed basically.
Yeah, just getting back really quickly to the question how to find good lawyers. As Max pointed out, there are many people who want to help, but not all of them are necessarily really of help. But to really tell, you need people on board. And this is actually the challenge that we are currently facing. It doesn't really help you if you only have I don't know, people who are not lawyers on board who have great ideas, and then you need to find pro bono lawyers somewhere around that bring your case. What you want to aim for is having at least some legal staff on board, because I think this is really why EFF and ACLU are so successful, at least in the digital realm, at least because that's the realm that I know, where I can more or less judge. I think this their question is the key to success is really that they have a legal team. They are not necessarily bringing all the cases themselves. They're not necessarily writing all the briefs, but they have at least the competence on board to really know what they should be doing. And I think if you're an organization, then it's a really, really good idea to try to get at least some legal knowledge in-house to be able to communicate effectively with possible external litigators.
Thank you. We had a question just here and here. Okay. Mike. Yeah. Thank you.
Yeah, I had a question about the crowdfunding. I think that was a really interesting strategy. I'm just wondering if there was any complication with respect to the applicable rules of professional conduct. For example, in New York, according to the rules of the bar, I mean, there's certain parameters that you have to follow for attorney advertising and similar issues. Did anything like that come up, or was it sufficiently distinct in that you funded the plaintiff and not the lawyers directly?
Yeah, we basically, in Austria, it's very simple to set up an NGO. You just have to sign a piece of paper and hand it into the government, and unless they turn it down because you're funding a new Nazi party or something like that, you're automatically an NGO within 2 weeks. So that's what we basically did. The NGO has its headquarters on the sofa in my living room, and has a bank account at a bank, and the NGO basically got the money. So it was separated from myself. It was, you know, only for this one purpose. I wouldn't be able to take the money and run or anything like that. And they would then have a contract with me as the plaintiff to basically fund whenever the money is out. And so this was all kind of in a legal order. And in Ireland, there is something like that you cannot fund other people's cases. And this was kind of mentioned once, but it's a very old law and the judge wasn't too interested in it. In Austrian law, there wouldn't be any problem at all. So that's really, again, a local law issue of how you can fund a case or not. In our case, it wasn't an issue. Another thing that we did is, in Ireland, the legal costs are just insane. What the lawyers are getting is an insane amount of money. So my lawyers are going to get about 200,000 to 300,000 euros by the Irish Data Protection Commissioner because they lost the case. And that's basically what I would have to pay for the other side if I lose a case. This case was interesting because an Irish court order for money wouldn't be, they couldn't execute that in Austria. So I was shielded in that sense. I mean, I didn't tell anybody and I didn't walk into court. It was like, if you make an order, you can't get the money from me anyways. But it was a safety net for myself to kind of sleep well at night. I was like, okay, I'm not going to have a summer house in Ireland then. The other thing that we got is what they call the protective cost order. That's something that they developed in the UK. It was never issued in Ireland, but the UK is typically, Ireland is typically looking at the UK for new, developments in the common law. And that was the first time in our case granted, because I knew that the judge wants to refer the thing to the European Court of Justice. I was like, I'm not going to pay for all of this. So if you're forwarding it to the European Court of Justice, I'm going to pull back the whole procedure and just rather lose on this level than paying all the fees potentially if I lose the case overall, knowing that the judge wants to refer it to the European Court of Justice because he just wanted to get it off his table. We applied for a protective cost order. My lawyers were like, oh my God, don't do this, because if he says no, you got to pull back the case and blah, blah, blah. It was a gamble in the end. I was like 99% sure he just wants to refer it there. So we got a protective cost order for a maximum of 10,000 euros, which meant I was 7 times over, we got like 7 times as much donations than in the end the maximum fee could have been. So that's a gamble as well. It really depends on your jurisdiction, what the options are. In Ireland, it's oftentimes UK stuff, and it really depends then.
Thank you. I think we had a question here. Yep. Do you have a microphone here, please? Thank you.
Is it on?
Yep.
Yeah. Okay. My name is Laurie Tanner. I'm an international human rights lawyer working on shining a spotlight on at-risk environmental, land rights, and corporate accountability defenders around the world. We're drawing your attention to the assassination a few weeks ago of Berta Cáceres, a renowned indigenous land rights and environmental activist in Honduras. Some of us are wearing buttons in her honor. Honduras is now legally liable for Berta Cáceres' murder. According to the only binding precedent in the world today, which is the landmark case of Jeanette Kawas, who was murdered 21 years ago at the same time as Ken Saraviva in Nigeria and Chico Mendes in Brazil. I'd like to invite any of you to come and pick up a copy of an article that I wrote for Oxford Press about the Kawas case and the case that came after it, which was a very controversial travesty of justice. Even though these cases, iconic cases, took place in the Inter-American Court on Human Rights, they have global relevance and can be cited as binding international law, whether it's in Cambodia, Africa, the Americas, anywhere in the world where there are human rights cases against environmental or land rights activists, human rights violations, whether it's criminalization, assassination, torture, etc. And if you don't want to pick up a hard copy piece of paper, it's on the website environmentaldefenders.org, environmentaldefenders.org, and you can download it in Spanish or in English. And I'd be happy to answer any questions if anyone has any. And I'm just sharing that this is a case to cite to in every setting, and we're bringing it to the UN Human Rights Council for the last few years, to the UN Forum on Business and Human Rights, because of the mentions of human rights defenders in the UN Guiding Principles on Business and Human Rights. We can interject the case on environmental defenders because the Guiding Principles mention human rights defenders twice. So environmental defenders are human rights defenders according to this case, which is the first time in the world that that's ever been expressed in a legal setting. Thank you.
Thank you. I think we have an immediate reaction to that, probably.
Hi, I had a question about, you were talking a lot about bringing different lawyers together to create a good litigation strategy. So I had a question about what happens when you have different lawyers that have different strategic approaches in terms of raising issues or in terms of moving the policy or moving the movement a little bit forward. Could you talk a little bit about the challenges that you've had, if you've encountered any of that, in terms of working with other lawyers that might have different approaches in that regard, especially when you have the same issue that you're trying to fight for, the same class action or the same type of clients, but you fundamentally might disagree on strategy?
I think Apar might.
I think to a large degree it's determined by the client eventually. Lawyers do have a large degree of say in public